Judgment in the matter of Zubaydah against the Foreign, Commonwealth and Development Office and others.
This appeal is concerned with the law applicable to torts alleged to have been committed by the UK Security Service, MI5, and the UK Secret Intelligence Service, MI6, which together I shall refer to as the UK services. The claimant, Mr. Zubaydah, is a Palestinian national who has been detained without trial by the United States authorities since 2002 and is currently held in Guantanamo Bay. The claimant alleges that from at least May 2002 to at least 2006, when he was being rendered to secret black sites by the CIA, where he was detained and subjected to extreme mistreatment and torture, the UK services sent numerous questions to the CIA for the purpose of eliciting information from him. The claimant seeks compensation for personal injuries which he says were sustained in CIA black site facilities in Thailand, Poland, Morocco, Lithuania, Afghanistan and Guantanamo Bay in the pursuit of the information sought by the UK services. These locations are referred to as the 6 countries in this appeal. The claimant has brought a claim in the High Court naming the Foreign and Commonwealth Office, the Home Office and the Attorney General as defendants on the basis that they are vicariously liable for the acts of the UK services. The torts alleged against them under the law of England and Wales are misfeasance in public office, conspiracy to injure, trespass to the person, false imprisonment, and negligence. The High Court ordered that the law governing the torts should be determined as a preliminary issue. The claimant argues that the law of England and Wales applies, whereas the defendants argue that the laws of each of the 6 countries applies. It is this issue that falls to be decided by the Supreme Court. The High Court held that the defendants were correct, but on appeal, the Court of Appeal overturned this decision and held that the law of England and Wales applies. The defendants have appealed to the Supreme Court. This is the sole issue before the Supreme Court on this appeal. It is a preliminary issue to be decided before the case can proceed to trial. It must be emphasized that this appeal has been argued and decided on assumed facts, on the basis of the allegations made by the claimant. No findings of fact have been made. This court dismisses the defendant's appeal by a majority of 4-1. The majority judgment is given jointly by Lord Stevens and myself, with Lord Burrows and Lord Kitchen agreeing. Lord Sales gives a dissenting judgment. The question of applicable law in this context is governed by Sections 11 and 12 of the Private International Law Miscellaneous Provisions Act 1995. Section 11 establishes a general rule that the law applicable to a tort claim is the law of the country in which the events constituting the tort in question occurred. Where the elements of those events occurred in different countries, the applicable law in respect of personal injury is, in general, the law of the country in which the injury was sustained. Section 12 states that the general rule can be displaced if, following a comparison of the significance of the factors connecting the tort with the country of the applicable law under the general rule, and the significance of the factors connecting that tort to a different country, it is substantially more appropriate for the law of the other country to apply. While an appeal court should be slow to interfere with the evaluation carried out by the trial judge under Sections 11 and 12, the majority holds that the Court of Appeal was right in this case to identify errors in the High Court's approach, which were sufficiently significant to justify the Court of Appeal intervening and performing the evaluation for itself. However, this court was unanimous in holding that the Court of Appeal itself fell into error when it proceeded to conduct the evaluation under Sections 11 and 12 for itself. It took an unduly narrow approach by focusing on the conduct of the UK services rather than the specific torts which are alleged to have occurred and which, on the alleged facts of this case, involved action by both the UK services and the CIA. As a result of this error, it was necessary for this court to conduct for itself the evaluation required by sections 11 and 12. At this stage, I reiterate that this appeal relates to a preliminary issue. It proceeds on the basis of the facts alleged by the claimant, and there have been no factual findings in the proceedings yet. Considering the test set out under section 12, the majority holds that on the assumed facts, the significance of the connection between the torts alleged and the 6 countries is massively reduced by a number of factors. First, the claimant was involuntarily present in the 6 countries because he had been unlawfully rendered to each in succession against his will, and could have had no reasonable expectation that the law of whichever location he was in, and which location was not known to him at the time, should apply to him. Second, there is no suggestion that the UK services were aware or ever took steps to find out where the claimant was being held. Third, the rendition took place without reference to the laws of the 6 countries. Indeed, on the assumed facts, it is appropriate to infer that the locations were selected precisely to deny any access to local law or recourse to local courts. Fourth, the fact that the claimant was held in 6 secret detention facilities in 6 different countries diminishes the significance of the law of any one of them. Fifth, the claimant's captors and interrogators were not the agents of the 6 countries, but of a third party, the United States. Furthermore, there are substantial factors which, on the assumed facts, connect the torts to the United Kingdom. First, the claim relates to torts allegedly committed by the UK services. Second, the events which constitute those alleged torts took place in part in England and in part by the CIA in the 6 countries. Third, the actions alleged to have been taken by the UK services were taken by UK executive agencies acting in their official capacity in the purported exercise of the powers conferred on them under the law of England and Wales. For those reasons, the majority concludes that it would be substantially more appropriate for the law of England and Wales to apply to this claim than the laws of the 6 countries. In a dissenting judgment, Lord Sales explains that he would allow the defendant's appeal. Lord Sales does not consider that the High Court made any error of law in assessing whether the general rule under Section 11 should be displaced in this case. He agrees that the Court of Appeal erred in focusing on the conduct of the UK services rather than on the elements of the torts. However, he concludes that it is not substantially more appropriate to apply the laws of England and Wales to this claim, and holds that the laws of the 6 countries should apply. Lord Sales considers that it is highly significant that first the claimant sustained his personal injuries and was imprisoned in the 6 countries, and secondly, that the CIA agents who are the primary alleged wrongdoers were present in the 6 countries and therefore subject to and answerable for their actions according to the laws of those countries. Lord Sales considers that the fact that the UK services were not the prime movers in the alleged scheme to seize, imprison and torture the claimant greatly diminishes the force of the connecting factor to England and Wales. The defendant's appeal is dismissed.